Hi, everyone. I'm Tanya Rivera. We are just a day away from the start of the third presidential impeachment trial in American history. At 1 p.m. Eastern Time, the Senate will convene before eventually hearing opening arguments on the articles of impeachment against President Trump. The first, abuse of power for withholding military aid to pressure Ukraine into investigating a political opponent. The second, obstruction of the congressional inquiry into his conduct. Mr. Trump's legal team, seen here leaving the Capitol, issued a response to the articles today, attacking them as flimsy. Their argument breaks down into four main points. First, they argue abuse of power and obstruction of Congress are not impeachable offenses. Second, the Trump team claims the House impeachment inquiry was flawed in its process. Third, they say the first article of impeachment isn't backed up by evidence. And fourth, they claim the Senate must vote for acquittal because the accusations are structurally deficient. Jeff Mason, Molly Hooper, and Kim Wehle join me now with more. Jeff is a White House correspondent for Reuters. Molly is a CBSN political contributor and veteran Capitol Hill reporter. Kim is a CBS News legal analyst and law professor at the University of Baltimore. Welcome to all of you. Kim, I'd like to start with this defense from the president's legal team. Help us to better understand what the Trump team is ramping up to argue.
They make a number of arguments. First of all, they basically try to set a new standard for impeachment that hasn't existed so far in American history. That is, that there needs to be a crime, not just a crime, but a crime that rises to the level that it subverts the Constitution itself. So it's almost blending abuse of power and a crime together. And they say here that the Democrats manufactured an abuse of power standard, and that's just not sufficient to abuse power. They also say the president has tremendous discretion over foreign policy, and that this is essentially an attempt to remove a president because Democrats disagree with his decision-making. On obstruction of justice, the second article, they make the argument that the president had legal defenses to responding to impeachment at all. That is that Pat Cipollone made the argument impeachment itself is unconstitutional, and they make the argument that these subpoenas were improper and that the president has every right to not respond to subpoenas that he believes are unlawful, and the Democrats should have gone to court to enforce those subpoenas.
Something that stands out to me, though, is that they are not arguing that the president did not commit an abuse of power. They are simply saying that abuse of power is not an impeachable offense, correct? And how does that argument hold up legally? We know this is not a legal proceeding, but how would it hold up legally?
Well, they do argue, they sort of argue a little bit around the edges on the facts. They say Ukrainian President Zelensky hasn't said that he felt there was a quid pro quo. Of course, factually, that's a problem because Zelensky needs additional aid ongoing. So he has every interest in making sure that he's not at odds with President Trump. But as far as the legal argument, the problem with the president's position is that it essentially leaves virtually nothing impeachable, except perhaps treason, which requires an ongoing war. They argue that bribery, they have to admit that bribery is impeachable. But the constitutional scholars that testified in the House impeachment inquiry, with the exception of my colleague Jonathan Turley, I think rightly made the argument that the framers were worried about a president taking the massive office of the presidency to stay in power, to use that extraordinary power, those levers of power, to entrench his or her power. And I think there's a strong argument here that that happened, and it's really different from a criminal process, which is violating a law to put someone in jail. It can't be the answer that the president can't be impeached because he has unlimited power to exercise the power of the presidency. That's kind of a checkmate. There has to be a basis where we, as Americans, don't want to see the presidency slipping into a monarchy, which is unlimited power. Clearly, the framers did not want a monarchy. People fought and died to reject a monarchy. So the question in this moment really is, where is the line then?
Right.
Where is the line that the Republicans would say conceivably could be crossed? Because if there is none, then a refusal to remove him here means a different kind of presidency, an ultimate presidency that, of course, is not always going to be in the hands of Donald Trump.
Right. All right. So, Molly, then how are congressional Democrats responding to this defense memo?
They call it dead wrong. In fact, at one point they say President Trump maintains that the Senate cannot remove him even if the House proves the claims in the articles of impeachment. That's a chilling assertion. And this is what they're saying. You know, if you go down a bit in their document, they say that the framers wrote the impeachment clause aimed squarely, quote unquote, at abuse of power, at abuse of office for personal gain, betrayal of the national interest through foreign entanglements, and corruption of elections. And they go on to say that that President Trump has engaged in the trifecta of constitutional misconduct warranting removal. He is the framers' worst nightmare come to life. So they're just doubling down on what they said in their initial brief. And I think that we're going to hear a lot of this pushback that abuse of power is somehow not a reason to be impeached or removed from office.
Right. And so, Jeff, what are these arguments then telling us about how the president and his team are going to argue against impeachment in this trial?
Well, I think number one, they're showing us that they want this to be quick. The president's team in this brief is basically laying out their contention that none of this is relevant, that none of this is right, and that the entire impeachment process is a sham, which, by the way, mirrors the rhetoric that President Trump has been using both on Twitter and in public for months now. So it's basically codified that in a legal document, or the document that was submitted to Congress. I think what that tells us about their strategy is that they are looking for a fast trial. It probably foreshadows something that they have suggested already, which is that they don't really want to have witnesses, although I think there's clearly still a question mark over whether or not that will happen. And it also says very clearly that their argument is going to be there's no there. Everything that the president did was okay, was justified, was perfectly correct, and that there's no reason that this impeachment should have come as far as it did.
But it seems to me if they're going to walk down that road of saying that everything the president did was correct, rather than just, abuse of power is not an impeachable offense, they're going to need to call in witnesses to confirm that. Wouldn't you agree with that, Kim?
Well, they also say that the House managers have a very high standard of proof. They argue that the House managers have to show that the president violated committed the allegations beyond a reasomable doubt. That is a criminal standard of proof that applies to put people in jail. It's very high. It's close to, 90-something percent. That's not established anywhere in the law. Most scholars would say it could be 51%. It depends on the particular senator who's making that determination. So I think their position might be, which is typical, I think, in a criminal trial, that, listen, it's not my job as a defense lawyer to prove a negative, to prove the innocence of my client. The burden is on the other side, the government, to prove that my client did what he's alleged to have done.
Right. And so, Molly, everyone, of course, wants to know, what are the rules of this trial going to be? What exactly is going to happen? And in a news conference last night, Senate Democratic leader Chuck Schumer accused Republican leader Mitch McConnell of keeping his chamber in the dark about the rules resolution that will be voted on tomorrow. So can you walk us through what we can expect in the first couple of days of the Senate phase of impeachment?
Well, I'd love to walk you through it. However, we also are in the dark. I can tell you what Republicans anticipate will happen. They anticipate both sides, the prosecutors, the House managers, and the defense, White House counsels, will have 24 hours apiece to make their opening arguments. And after that, there will be about 16 hours of questions that senators can submit through the Chief Justice to ask questions of either the prosecution and the House managers or the defense. After that, and this is based on what the rules of the road for the Clinton impeachment, after that, both sides could move to dismiss, or they could after moving to dismiss, both sides would have 3 hours apiece to make a case for witnesses, and then after those cases are made for witnesses, both sides, the Senate could vote on a motion to dismiss and then vote on whether or not to have witnesses. So that's the way it's supposed to play out, according to Republicans who still haven't all seen this rules package. What may happen on the Senate floor tomorrow is anyone's guess,
Right.
because Mitch McConnell is holding this procedure package very close to his chest. He doesn't want a lot of people to see it because then you can start, then Democratic senators can start figuring out which procedures to challenge on the floor. I have a feeling we'll hear a lot of motions too, ... and perhaps votes on overturning the ruling of the chairs. But ultimately, we'll end up at that initial package that I laid out. Both sides getting to make their case, take questions, and then make their cases for witnesses.
And Jeff, since, as Molly just said, one of the big open questions is whether or not senators will vote to call new witnesses. Who are the senators that you are most closely watching in this vote?
Well, certainly on the Republican side, watching Mitt Romney, watching Lisa Murkowski, watching Susan Collins. Those are moderate senators who have indicated an openness to having witnesses, and they are voices and votes that Democrats would need to sort of get over the line for a majority to get people on their side. For that kind of a vote. So that's, I think, who people are watching very closely. I think it's right that we won't know about that for some time, because that's, even if Senator Schumer, the Democratic leader, tries tomorrow to have a vote on that, they're not going to have the votes that they need for something like that tomorrow, but possibly later in the process. Senator Collins has said she wants to hear the evidence, she wants to hear the arguments, and then perhaps be open to witnesses after that.
And Molly, as the senators are likely to vote, if they decide to have witnesses at all, they're likely to vote on each specific witness. Who are the witnesses you think are most likely to make it through that gauntlet?
I think John Bolton, that's the name that everybody has been mentioning, and Bolton has said if subpoenaed, he will come and testify. I'm not sure that we will see Mick Mulvaney. I think that would be a challenge through the courts, but the Democrats will try to get the chief of staff, or the acting chief of staff's close confidant, Robert Blair, and possibly Michael Duffy, who is at the Office of Management and Budget and is in charge of the national security budget. He would be the individual that refused to allow the money to be spent in Ukraine, to give the funds to Ukraine. And senators want to hear why that was, of course. But if Democrats make their case, expect Republicans to make their case for witnesses as well. Individuals on that list could include Hunter Biden, possibly the whistleblower that basically kicked off this whole investigation, among others who may have played some kind of role in what Republicans suspect was, Democratic interference with with our elections, and so we'll see which names come out of there.
Do you think Lev Parnas will come up?
Well, Lev Parnas could come up as well, but again, but he may be a little bit tricky because it's sort of like Michael Cohen over on the House side. This is a guy who's been indicted for he has his own legal problems, and I think that what the Democratic senators will want to do is have his documents and the evidence that House Democrats have been able to glean from him,
right,
submitted as part of the record. But whether we see him giving a deposition or in front of the Senate is another question.
And so, Kim, Parnas' attorney is asking the Justice Department for the recusal of Attorney General William Barr from Parnas' investigation and prosecution, arguing Barr has a conflict of interest in this case. Last week, Parnas told media Barr, quote, had to have known everything President Trump's team was doing in Ukraine. Is this rather extraordinary request something that we can expect Barr to even entertain?
Well, whether it's an extraordinary request and whether he will entertain it are two different things. I mean, remember, Jeff Sessions, when he was Attorney General, he recused himself from the Russia investigation because he was involved in the campaign. So there are ethics rules that govern federal officials, including lawyers, that essentially if you're in a position to make a decision about someone's prosecution, you shouldn't have any personal interest in it. And Mr. Parnas' position position is that Mr. Barr had knowledge of what was going on, that Mr. Parnas was involved in terms of both the firing of former Ukrainian Ambassador Marie Yovanovitch, as well as the request that President Zelensky announce an investigation into the Bidens, a bogus investigation into the Bidens, in exchange for release of aid. So Parnas's position is, I'm now potentially a witness against Mr. Barr. Essentially, I've publicly said that Mr. Barr was involved in conduct that has given rise to impeachment of the President of the United States. He should not be in a position to make decisions about the prosecution of me. It seems like, in an abundance of caution, Mr. Barr, there's a good argument for him to recuse himself. But of course, there's a lot of issues in this moment with people within the Trump administration sort of winking at these allegations and not really doing anything to address them. We have Mr. Mulvaney, who's implicated. We have Mr. Pompeo, who's implicated. Mr. Bolton, the Vice President of the United States, was also implicated by Lev Parnas. It's not to say these are all legitimate, but we do know, for example, that the July 25th call summary referenced Mr. Barr. The President of the United States told Zelensky to call Mr. Barr. We also know Lev Parnas implicated House Representative Devin Nunes, and there are AT&T phone records confirming that he had communications with Parnas. So at the end of the day, if this were a regular criminal or even civil process, all of these facts would have been developed either through a grand jury or investigative process or in what we call discovery in the civil case. So it wouldn't come to trial until all of this stuff had been uncovered. So it really is, for a lot of reasons, truncated. And the losers are not Democrats or Republicans, but really the American public, who are not going to see all of the facts.
Yeah. Absolutely. Well, Kim Wehle, Jeff Mason, Molly Hooper, we've run out of time. Thank you so much for joining us.